Welcome to Hot Topics in the Workplace when medical conditions flare up. We're delighted to be back here again. We took a little longer hiatus during our summer break. We usually take July, but just things were too busy in August. We just couldn't work it in. So here we are in September. Welcome to everybody. And in case you know people who wanted to attend, who couldn't attend, please ask them to send me an email so that I can make sure that their name gets on the list, because only those registered receive the recording. Okay, that's the benefit by being part of this group and signing up in advance so that you can receive the recording. So thank you, and Felicia, so great to be working with you again. Thank you for being my co-host.
Yeah, I'm happy to be back, ready for the school year start.
Very good. Very good. Yes. And for all of our participants today, we are going to ask that you keep your cameras off but keep yourself muted. If you have a question, please raise your hand or put something in the chat boxes. We're happy to answer questions as we go along. But we have a packed agenda today. And so to give you an idea, and our first four are actually live cases that we're dealing with currently. And then, of course, we always like to provide an EEOC update. And so there's a couple of very interesting ones that we'll touch before we conclude today. We generally go for about 45 minutes max. And so so you can plan your time accordingly. Okay, so let's get started. We're going to talk about medical conditions that change or conflicting perspectives. The second one will be, what if you have an employee with limitations and now they're applying for a new job, IPM or interview? It's an interesting one. And then also, this is a really interesting case, and we'll look forward to talking about it. No limitations, but the doctor uses the word prudent to make prudent actions. So that's an interesting one. And then the motorized scooter. Are you responsible for providing it or not? And is it an undue hardship or not? And then the QuikTrip and EEOC is an interesting one on modified work as a schedule, as an accommodation. And then who is the decider on whether a medical condition meets the ADA guidelines? And I thought we'd resolved that issue years ago, but okay, it's back up. Okay, so let's get started, Felicia, because I know are busy, and I know that there's a lot of important information we want to get out there. So when medical conditions change, and conflicting perspectives exist between the employee and their doctor. So this is a very interesting one, right?
This is an interesting case that's going on right now. Original position was an instructional aide 3 at a fairly large school district, and she was temporarily accommodated and had a prior IPM. And then as the notes went along, because the whole return to work process is like a river, things are changing all the time, she did receive release to full duty from her doctor. So the district was thrilled. They called her up to make arrangements for her start date. And that is when she told them that she had a new note, that she had gone back to the doctor and that she didn't feel that she could lift over 50 pounds. And that really threw a wrench in everything, because then nobody knew about this new note. So then this new note, this is a work comp case. So the new note stated, the doctor said the employee could not handle 50 pounds after reviewing the job description, and that lifting of students and diapering was really one of the main problems. The prior notes that the employee had was a 15-pound temporary limitation, which the district was able to offer an alternative position previously to accommodate that. So it was interesting, because some of the questions that they had was, because this was a temporary work restriction, were they able to offer long-term, or accommodation would be reevaluated, or whether it would be a short-term. And that's some of the discussion that went on, right? We could do this short-term maybe until you return to the doctor and we see where this goes. And the temporary accommodation that they had talked about was lower pay than the original pay of the IA3 position. And that was a topic of discussion. Do we drop her pay? And then it was discussed that no, during a temporary accommodation, pay remains the same as the pre-injury pay, and then we'll reevaluate as we go along. I think that's where you guys ended up landing.
Yes, absolutely. And so let me just build on that last piece there, because yes, during temporary accommodation, because it's a temporary situation, the pay doesn't change. They get paid the same whatever they're doing. Because sometimes temporary accommodations may not be an actual job, but a collection of tasks or projects that school district might need to have done. And so again, the pay remains the same. Even if they go to work for another department, it still is your original department's responsibility until somebody reaches maximum medical improvement. And then long-term accommodation, if somebody's going to a lesser paying position, then that's when all the salary adjustments occur. And I always like to emphasize too, Felicia, that an employer can offer somebody any job, no matter what it pays. So don't feel that you can't offer it, because I have seen employees who have accepted lower paying jobs that are outside the workers' comp guidelines because they want to stay working for their district. And so again, you can offer anything, but again, the employee has the right to decline the offer if the offer is greater than 15% difference. And I always like to emphasize to employees when I'm facilitating the IPM, that doesn't mean there's any guarantee for future employment with your same district. It just means that you're entitled to retraining money. If you get retrained into a job that exists within your district, then yes, then we can reconsider. But yeah, so it's some nuances in there that are really important to clarify. And I would also say on these differences in between the employee and the employer, we are doing a follow-up IPM actually this Friday, and the employee still differs because the doctor is still talking about no long-term accommodations, but he is giving her a temporary accommodation. And
Right.
and so I think she had reached MMI, and so now it's okay, flux. We're supposedly at MMI, but then again, now you have a temporary accommodation. So is she not MMI or what? But I think we're going to have some more pushback, shall we say, about the employee coming back to her usual and customary occupation as an instructional assistant in healthcare. Yep, yep. Okay. Now this is a very interesting one. We have an existing employee who's had, I believe it's a work-related injury, or is it is it a separate?
It's a work comp
Okay,
injury.
that's what I thought. So I haven't done the IPM here, so Felicia's going to address this one a little bit more, but I've been involved in the exchange of communication. And so the employer doesn't think the employee can do the new job.
So this is the original position was a sped parrot,
Mm-hmm.
and this person is being temporarily accommodated in a different type of school setting, a different classroom setting that is something that they could accommodate with the temporary work restrictions. While on temporary accommodation, the employee decided there was an opening at the school district that she wanted to apply for. And this is what really threw the administration when everybody was asking a lot of questions, because they were very concerned because the work restrictions that she already has that are being temporarily accommodated now were also going to be a concern for the new position. So they had many questions about, should we allow her to apply for the new job? Should we allow her to interview for the new job? Should we tell her that no, because she's on temporary accommodated duty for a prior injury, she can't interview for the new job? We're worried about a lawsuit and discrimination issues. Or should we go ahead and let her interview and then deal with the work restrictions and a possible IPM later? And we got a whole
Mm-hmm.
series of questions
Yeah.
from them on that. And I know you had comments about that.
Yes, when just going back to the whole practice, one thing, basically all those options present issues for the employer, okay? Because one of the things about accommodation and medical conditions in the workplace is that you're not discriminating in a way that denies the person the rights and responsibilities of employment overall. And so if the employer was to decline or to say that the employee can't apply, that's not appropriate. You need to let them apply. Denying them an interview, again, if they've applied and they meet the qualifications, then again, any other employee would have a right to an interview. So those both would lead to other employment actions that would not be good for the employer. And in this particular case, that one of the things is that that's the beauty of offering someone temporary work elsewhere, is that they can gain skills that then do qualify them for openings as they exist. So there's a three-step process, everyone. One, it's got to be an open position, okay? And this is for long-term accommodation. An open position, the employee is qualified for a lateral or lesser position, and then you address the limitations and whether or not accommodations are needed. And so that's where the interactive process comes in, because again, if you're making a decision that the employee can't do it, and yet the employee is doing the temporary work, whoa, you're no longer in the interactive process and you've got the employment issue on ADA for failing to engage the employee in an interactive process. So you have to go through the steps in this case. And I would actually, I think in a way it could go the interview and then the IPM, or have the IPM up front, because you already know that the employee
Mhm.
has a medical condition. You already know that the employee has limitations. And so having an IPM to address the concerns about performing the new position before the interview would still be appropriate. Because again, under the ADA and FEHA, there's a failure to engage liability there. And engage a
Mhm.
person, you've solved 99% of the problem, okay? And it's only if it's promotional does the employee have to be the best qualified. By not having an IPM, not allowing the employee to interview would clearly be a violation of our laws that we work with in accommodation. Again, letting the employee interview would be one way to get more perspective about the employee's
Mhm.
qualifications, but then that's where it's incumbent upon the employee to disclose that they need an accommodation. And okay, what kind of accommodation? And then that might need to be evaluated further. That's where the IPM can come in too. So I see
Mhm.
where either one could go first, the failure to do either one.
And you know what they did, because the interviews were that day, the day that we were
Yeah,
having back and forth exchanges. They did go ahead, this employee did apply and did interview, and now they're going to have in follow
yeah,
up with an IPM to discuss, because they already know what the work restrictions are, right? Because
yeah,
she's
right,
already on temporary accommodated duty. She's not really a new candidate in the way that we think of new candidates. She's
right.
an existing employee who's applying for a different
Mhm.
position.
Yeah. So again, I just want to emphasize, and not because I facilitate them for a lot of districts, but you can't go wrong by engaging an employee with a medical condition in an IPM. Again, the failure to engage is more critical than the failure to accommodate. Because if you never engage, then how do you know if you can accommodate?
Mm,
So
right.
always a sure bet if you get involved in the IPM, even if it's managed internally. Okay, the next one, the prudent action versus actual functional limitations. Go ahead and start, because I have a couple thoughts about this one
Yeah,
too, and I
this
know
is
you know more about the
so,
case.
so interesting. So this employee, this is I believe that this is I'm trying to remember if this is a certificated teacher, but I think it is. This is a work comp claim. This employee was deemed MMI by a neurological QME who was addressing head injury with cognitive impairment and headaches, chronic
Mhm,
headaches. And where the neuro landed, which really confused the district and the Athens claims team, because return to work is not their specialty, special expertise, was that there were no formal work restrictions for the injury. From a neurological perspective, the person could do their usual and customary job duties. But every time there's a but, that's when I always tell the Athens team, all of that has to go to the district.
yeah.
Certain things may be prudent to allow for short, self-directed breaks during periods of prolonged cognitive load or screen use to mitigate symptoms of mental fatigue or visual overstimulation to minimize high stress environments if such conditions are found to exacerbate the post-traumatic headaches or the cognitive symptoms. And this is based on subjective, not objective deficits. This is based on symptoms,
Hmm.
objective symptoms, basically the employee's symptoms. So there was a whole long sentence after the part that said she has no work restrictions.
Hmm.
And then what happened was the claims team said, there's no work restrictions, you're good. And I said,
Hmm.
no, we're not good, because certain things may be prudent.
Hmm.
To me, that language is a physician's recommendation still. And still, I think, my opinion, triggers the need for an IPM, because this person's MMI. They're
Hmm.
permanent. These comments. Now, if these comments weren't made, then they're not made. But they're made and they're there, which means we
Hmm.
know about it and we can't not know about it. So that all
Hmm.
needed to go to the district. And where the Athens claims team landed was, do you want to do an IPM or not? And I felt like that whole but, and because it was a long paragraph of what I call physician recommendations, may be prudent to me. I don't know what you think about that language, but.
Yeah, I absolutely agree with where you're headed on this one. And I'm sure all of our participants today have probably seen the language preventative issued
Mhm.
by a doctor. It's like that. The
Or
doctor could have,
prophylactic,
yeah,
right?
or
Prophylactic.
prophylactic. Yeah. So it could have been prophylactically, I recommend this. I recommend this. Two distinctions that are important. It's just a different use of the word prudent, but work restrictions are used to define the percent of disability in the workers' compensation claim. Okay, workers' comp. Okay, prophylactic, preventative. The case is not probably going to be worth much because there's no permanent disability per se, per the doctor, but there are things preventatively or proactively that the employer, from an accommodation standpoint, should take into consideration, or they could end up with another workers' comp claim or having the claim reopened. And yes, so from a workers' comp standpoint, no work restriction. Got it. But from a return to work perspective, definitely we need to
Mhm.
look at this. And that's just for those of you who have been with me in IPM. You'll hear me always ask, here are the doctor's work restrictions. Do you agree or disagree with that? Do you feel you can do more, or do you feel you can do less? And then how do you see yourself impacted both in your activities of daily living, both at work and at home? Help me understand where you're challenged. And sometimes the employees may feel that they can't do as much, even though they agree with the limitations.
Mhm.
They may feel more limited in how they do things, which is important information for us in the workplace to understand where they may be challenged. And again, making sure that they're able to perform all of the essential functions. That's the key. It's all about restoring people to full performance of the essential functions, but taking into consideration what the employee feels that they might need, excuse me, whether or not it's a permanent work restriction. But then also to say, okay, temporarily we can do this and let's see if we continue to improve. And so sometimes we need to do things on a trial basis. And the ADA,
Mhm.
Jan are all behind doing things on a trial basis to see if it works or not, because it may or
Mhm.
may not. Okay, if it doesn't, then we'll go back to the drawing board. Because again, the work restrictions give us guidance, but it doesn't tell us necessarily how to perform the job. That's so it's so important with work restrictions, because sometimes we'll see a lot of work restrictions, but then as we dive into it and then actually look at the job description, sometimes limitations don't really impact the job performance. But because they have limitations, we're still going to call it modified work because the employee may actually implement their own self-modifications. That's modified
Mhm.
work. Yeah.
And I used this as a teaching moment. I told the
Mm,
Athens claims team, I know that the return to work and IPM is ADA FIHA, not your expertise in work comp and the labor code, but it's very important that when we go through these
mhm,
reports,
mhm.
anything, and I mean anything that has to do with return to work. So I don't care if it's preventative, prudent, work restrictions, limitations. I also will see this language. This is the doctor stating, the person can return to work, but they should not be doing blank and blank. That has to go to the district because that is also a limitation. Even though he's putting his own, I think it can be accommodated. That's out of their purview to make that
Yeah.
decision. But it is confusing for the examiners because they really look at, they can go back to work or there's no work restrictions. We're done. That's the end.
Yeah.
But when I see a paragraph like this, it really concerns me,
Yeah.
especially with a
I'm
heading.
Yeah, yeah. And Felicia, I'm going to take this opportunity because we've talked about this offline of late as well. But when we have psychiatrists or psychologists say the person can return to work, but not for that supervisor. No, and I've been battling that concept for over 20
Yeah.
years. That's
Mhm.
not good enough, doc, because we could be sending her to a supervisor who's even worse than the one that they have.
Mhm.
So
Right.
help us understand, what is it about the behaviors? What is it about their interaction? And again, the employee should be able to improve over time if we know what we're dealing with. And
Mhm.
and so for all of our employers out there, push back on that one. We need more information, and that needs to be explored with the employee as far as what is it about this interaction. Because as we know, we had a case where an employee couldn't work for her immediate boss who oversaw her whole class of jobs. Then she couldn't engage with the assistant superintendent that was over that
Mhm.
person. It's like, I'm sorry, if you can't engage with your supervisors, that's a problem. Yeah. And usually interpersonal interactions and good relations are an essential function of job ability
Mhm.
to get along with
Right.
people.
Yes.
So yeah, yeah. Okay, so I got my soapbox there. Thank you. Okay, yeah. So the motorized wheelchair scooter, for this is non-industrial. The employer is thinking it's an undue hardship for them. And I'm going, what? Why?
Uh,
And then,
This is a very interesting case. We get involved because we get asked a lot of questions about
yeah,
fit for duty and non-industrial IPM and doctors that will do fit for duties because that's something that both you and I get involved with. So the initial work restriction that came in, and this was earlier on in the year, was number one, wear a boot at all times. This is for a foot problem, I think.
yeah.
Number two, no more than 5 minutes an hour, 5 minutes every hour of standing. This is a certificated teacher. Number three, there must be a chair, access to a chair at all times, like in the classroom or wherever
Mm-hmm,
they may be. And number
mm-hmm,
four, refrain from all field trips, which was especially troubling. They did hold an IPM after this note, and temporarily they did accommodate a temporary accommodation where they would get a sub for all field trips because that's normally something that the certificated teacher does. And then the employee would enter that as an absence for the day. That's where they landed as a
mm-hmm,
temporary accommodation. And then they provided the employee was wearing a boot. And then they got an updated note that these restrictions were indefinite. Several chairs were placed in the classroom so the employee could get up and walk around to assist students in the classroom, but could also sit down as needed. And then they now have noted, now the new school year has started, this employee's having trouble standing, needs to lean against things to support them while standing, and they visually notice they're even having problems ambulating, just
mm-hmm,
walking around campus. And then the employee said, hey, I think what would really help me is if I had a motorized wheelchair, and they're very expensive for those of us that have bought
mm-hmm.
them on work comp claims. They're
Yeah,
thousands of dollars.
yes,
And that was just where the employee came up with, this is the solution to all of these problems. I just need a wheelchair. And obviously, what we advise that an IPM on a non-industrial basis, whether you do it on your own or with a mediator, was the perfect way to address all of this because it was getting quite confusing, right?
yes. Yeah, and so this is a situation where, if I recall, Felicia, they were questioning whether or not they should do a fitness for duty versus an IPM. And so it's like,
Correct.
again, I'll just say I always recommend doing an IPM before you go to a fitness for duty, get
Mhm.
more information. And that comes back from my early days of working directly with EEOC representatives, is that always get more information. Again, you can't go wrong by holding an IPM. And rather than making assumptions or
Mhm.
guessing, I like to say making assumptions is not the problem, it's acting on them without enough
Mhm.
information. And so an IPM would help get you more information, explore different options. And in this particular case, or in any non-workers' comp medical condition, this is the distinction. It's not your responsibility to purchase or provide a motorized wheelchair or any wheelchair for that matter. That's the employee's responsibility. The employee should be working with their doctor to get a medical prescription to then submit to their insurance company. A lot of insurance companies won't openly talk about this because they're expensive, but it's called
Mhm.
a durable medical equipment,
Mhm.
DME. And I just had an IPM yesterday where the employee was not given, pretty sad situation. The employee was not given a motorized wheelchair. Her son actually bought one for her. So that's
Mhm.
not right. Your
Mhm.
doctor should be writing you a prescription, and her disability is clearly evident. And so where the employer comes in is that your accommodation of the employee with a motorized scooter would be to allow for it to be on the property. And so any kind of liability factors, things like that. But then you have to make sure, is the classroom close enough to the nearest wheelchair accessible restroom or a
Mhm.
ramp if there's any stairs involved, etc. Because I've dealt with a lot of ambulation issues. That
Mhm.
is what, okay, we don't remove essential functions. So again, in this case, we don't remove going on field trips. Temporarily, we might to see if the condition improves, but that's not a long-term solution. We don't remove essential functions, and going on duty field trips is one of those things. So again, what are your options? And this is where some of you may recall that I've recommended a walking cane that has a collapsible seat so that they can sit down periodically for a
Mhm.
brief moment to give them some respite from walking. But like in your situation, that we just had this come up at the end of last school year, the employee wanted to continue working remotely, which had been provided on a temporary basis, but it was not, the job was not getting done and she needed to be on site. and yet walking was an issue. And so then that's where I got involved and wrote to the doctor, and if she was using a motorized scooter or wheelchair, would she be able to then come on campus? And it's very accessible. So we'd already gone through that. And the doctor finally said yes. So now we're getting into the position of facilitating her return. So again, the district's not responsible for purchase. The employee is for a non-work related condition, and your responsibility for accommodation would then be to how does use of the wheelchair impact performance of the duties? Because all kinds of people use wheelchairs, and using a wheelchair doesn't mean you can't teach and or accompany your students to and from places. And so it's just a matter of ambulating differently by using a motorized device. And as the question came up, they were considering it an undue hardship. I don't think the law would be on your side. You'd get dinged pretty fast if this went to court. Yeah.
I think the employee said, I want you to pay for it. That's
Oh.
where that was the undue hardship was not so much them accommodating this employee having a wheelchair. It was the employee said, I can't afford to pay for it. You need to buy me a motorized wheelchair. And then I told them, wow, we just don't see that. That's just not something we see as a reasonable. That was what they felt was an undue
Oh,
hardship,
okay.
was the
Okay.
purchase
Oh,
of it, not having it. They said,
okay.
you need, the employees, the teacher said, you need to buy me one and
Yeah.
pay.
Yeah. Yeah.
I told
Yeah.
them because we buy them, we buy
For
all
workers'
kinds of
comp.
food and scooters and wheelchairs, and we rent them and we buy them, but that doesn't matter. They're very expensive either way. Some group health companies do pay for it, some do not, right? So that's a conversation with your doctor and your insurance company. But you're right, you
Yeah.
have to get a prescription, but it's not usually you take the prescription to work and they buy it for you. This
No.
is the DME equipment that's usually an insurance issue or a U issue.
Yeah. And real quickly on that same note is that if someone's health care insurance does not provide it, which is pretty unusual because it's a DME, they just don't like to tell you about it. But there's also then through the Job Accommodation Network, they have regional technical advisory centers. And I think there's 6 in California. And so by going to RTAC, Regional Technical Advisory Centers, they will work with you to get those kinds of special devices and things like that. Again, if you can't ambulate that, but you can't provide it on your own, then a leave of absence might be appropriate until they go through the proper steps to get it, but not
Right.
to remove essential functions. Okay.
Yeah.
Okay, we want to get onto the two EEOC laws, and we have about 10 minutes left. So I'll just let you take it away because I know you know these cases better than I do.
So the first case is they decided to settle. This is a little market. QuikTrip hired an employee in a full-time position back in October of 2021. So then come forward to March of 2022. So they've been there about 5, 6 months. The employee submitted a reasonable accommodation request asking the employer to modify their work schedule and some of their duties due to medical restrictions. For some reason, the employer initially intended to accommodate the employee's requests. Somehow it misinterpreted the reasonable accommodation requests and they reduced the employee's full-time work down to 9 hours a week or something like that, and forcing her to resign because she couldn't live on 9 hours a week worth of work. So then she sued, right? She filed a FEHA and EEOC action after discussion with EEOC, and they didn't even get to the litigation stage. There were some discussions about, wait a minute, what happened? You didn't engage, you didn't interact, you didn't have a discussion, you just cut her hours down to 9 hours a week. And how is that an accommodation anyway? So then QuikTrip agreed to pay $35,000 to not litigate any further and to settle the lawsuit. And then what also happened was they agreed to hire a consultant, someone like yourself, to improve and educate all their supervisors and their managers and their HR workers about their responsibilities and the employees' rights under the ADA, and especially about laws about discrimination against people with disabilities. And then in addition, the employer agreed to provide reports to the EEOC for the next 2 years about how they were doing with that because this is a big company that is all over the United States. It's like 7-Elevens is what
Yeah.
the impression that I get. And so this was just a total fail, right? They didn't meet, they didn't have a discussion, they didn't talk about the disability. They just said, you wanted reduced work hours and duties, boom, you got it.
Yeah.
You now work 9 hours a week. So they settled for obvious reasons, right? They thought that they were going to lose that case.
Yeah, and they probably would have. Yeah, yeah. And just as a note then to everybody is that when a case like this goes to EEOC typically not in addition to the punitive damages, and each ADA claim is going to be at least $300,000, not even to get to, not even including, I should say, any lost wages, any pain and suffering, etc. And then what they will frequently do is order the company to engage in company-wide training on whatever the issue is. I used to do a lot of this work with the stevedoring companies on discrimination, particularly when sexual harassment cases were found. Because when women started entering that workforce, all kinds of problems would happen. But yeah, so education is really a key component, but then also monitoring and follow-up. So 2 years is actually relatively short. Usually it's 3 to 5. Yeah, yeah, very good. Okay, and then the next one, who's to decide whether a medical condition meets the threshold for ADA accommodations? And this is a case involving Walmart, right?
Yes, this is a case that is not settled and not resolved, and Walmart is still fighting. This case is still being litigated. So this is an employee who worked for Walmart who had a torn ligament. And I believe this was in this employee's feet or foot. And the employee allegedly developed a torn ligament in one foot and had a limp due to a physically demanding schedule at work that required about 15,000 steps of walking per day, each day. So
Oh,
obviously you can imagine what they're doing. They're walking all around Walmart all day when they're working. So she requested two things under her reasonable accommodation. She requested FMLA leave to try to get some medical treatment for this torn ligament. And she also asked if instead of that, maybe for short hourly stretch breaks, and this was per her doctor's recommendations to try to help her deal with this torn ligament. She was denied both, and then she was fired the next day. So then Walmart filed for summary judgment. And Walmart argued that the employee was not a qualified individual under the ADA because she had an intermittent injury that was not long-term or permanent. They decided that. The judge rejected this argument, saying it's too soon to say how lasting her disability will be. And the judge offers a few lessons for employers in how to approach their ADA requests. So this is what I call a cautionary tale. Number one, with little information, it was not for Walmart to determine the nature of the employee's disability. Walmart said that it was intermittent, episodic impairment. It wasn't a disability, i.e., like a broken leg. Two, the judge said Walmart hadn't shown the employee's injuries to be intermittent. There was no indication that the injuries come and go when they didn't have a meeting anyway, so how would they know? Because there was no IPM. The judge also said that Walmart's objections were threadbare. The Walmart was saying that the note wasn't good enough. It wasn't elaborate enough. And the judge found that the employer's only entitled to a short and plain statement of the injuries. It doesn't have to go on and on. While the employers are within their rights to ask for a note, they must engage in an IPM to clarify what is needed and identify a suitable accommodation. And leave is often a common form of reasonable accommodation, the EEOC noted. So obviously this case, Walmart did update this just like the other day and say that they feel that they accommodate a lot of injured employees. In this case, they just have a lot of problems with. But it is an interesting case because of the lessons learned, right?
yes, yeah. Very clearly, because I mentioned already that, gosh, I thought we dealt with that issue a long time ago. Back in the 90s, when the ADA first passed and FEHA had passed a couple years prior to that, just took the feds longer. The first, I would say 7, 8, even the first decade after the ADA passed, that's where a lot of litigation was. Is the person qualified? And finally, the EEOC, after enough judges handling these issues, said, that's not where you want to quibble. Okay. Who are you as employers to decide, what's a disability? And again, that's why the terminology of medical conditions came into play. And again, to work with your employees on a temporary basis to see if the condition doesn't improve. It's just like in the workers' comp cases we have. And so we got past that. And then the last couple of decades have been more around these kinds of things, failing to engage, failing to provide adequate accommodation. And that's why I always encourage all of our participants today is be explorative, be curious. Well, what are your challenges? What can we do? Is this temporary? Is this long term? On a temporary basis, yes, maybe we can do that, but let's see if it gets better. And so rather than forcing someone out or losing a qualified employee, all kinds of things.
Yeah, and I think I agree with you. I think flexibility is so important because the one thing I see on the work comp side a lot, and I know you see it on non-industrial, is the people flow through from I have a temporary accommodation. Some of the examples we used in the beginning of this session, I'm able to return to full duty work. Now I'm off on a temporary accommodation again. Now I have a permanent accommodation. Now I'm back to full duty work. You've got to be a little bit flexible, right? Because things are changing. And one thing that the judges, why he didn't rule for Walmart in this case, was he said, you overstepped your bounds. You were trying to determine what is a qualified individual, qualified disability, and you also were trying to formulate whether this was a temporary condition or not. And you never had any discussion, and then you fired the employee the next day without having an IPM at all.
Yeah, yeah, yeah. So again, it's a wise investment for a good payout rather than going to EEOC and again failing to engage. So always seek to engage the employee in some form or fashion about what their condition is and how long term, et cetera, et cetera. What you just said, Felicia, also triggered me. I actually have two cases right now where the employees were actually released to return to work full duty, and then for other reasons that I'm not involved with, finally got to a QME, and then QMEs tend to be a little more precautionary, shall we say, and so now they have long-term limitations. And
After working full duty for a long time.
yeah. And so that's where let's explore how do these limitations actually impact the work and what can be done about it. And many times by that time, employees have made self-modifications, but sometimes they've worked with their employers to improve the nature, the method and manner of doing the work that makes it safer. And in both cases, the employees were able to continue working, but again, it was like, what? This is shocking. We didn't know this.
It really throws the district off when that happens because they've already had a full release that they've been operating under maybe for 4 or 6 months by the time they get to a QME. And a primary treating physician is much more likely to write you a full release, even though they think you should have work restrictions, than a QME is, because a QME sees you one time and they don't have a relationship with you and they don't ask you what their opinions are going to be. Whereas your relationship with your primary treater, if they tell them, I'm going to lose my job if you write one thing about work restrictions on my note, then they really heartstrings. Then it's a harder thing to do because it's somebody that they did surgery on or that they have treated for a long time. So,
and the other thing on that too, that we see treating doctors are more likely to write what their patients want them to write.
yes.
And so I have an employee that did develop a condition, is not work related, but did develop a condition, convinced her doctor to release her to full duty, and now she's back with limitations again. And so that's actually a couple different situations of where employees have convinced their doctors to release them. And so that's not really in your best interest. And
Goes under the is it safe, right?
Yes. Felicia, we have covered quite the ground today. And thank you so much for working with me and providing all this great information to all of our participants. Always a delight to work with you.
Oh, I feel the same way. I love working with you.
Thank you. Thank you. And I think all of our participants here today see lots of familiar names. Again, as a reminder, we will be sending out a follow-up email providing you with the link to the recording and with meeting highlights. And so do look for that. Today's Wednesday, so it may not be till Monday or Tuesday. Just other things ahead of getting this out to you, but you'll have it early next week. And we'll get back on track with our regular monthly meetings now that we're over the summer and everyone's back in school. Very good. Thank you again, everyone. We appreciate your participation, your use of our services, and wishing you all the very best in this new academic year.
Yes.
Okay. Thank you again, everyone, and look for your emails early next week.
Happy fall.
Yep. Bye-bye.